A vicar who says he was driven out of his Worcestershire parish by vindictive parishioners has taken his case against the Church of England to an employment tribunal in Birmingham. The case has attracted attention partly because of the lurid picture of rural life painted in the Revd Mark Sharpe's allegations, and partly because it could be a significant legal landmark. Gavin Drake has been covering the case, and he told me what he made of it.
An extraordinary picture is the way to describe it. There's been widespread publicity for Mr Sharpe's claims that his dog was poisoned, his car tyres slashed, and other acts of harassment carried out against him over a number of years. But if people were looking for a Midsummer Murder-style expose during the court this week, they would have been disappointed. This wasn't the case where Mr Sharpe could air those grievances. This was a case to decide whether he has the right to bring those grievances, and specifically whether Mr Sharpe is an employer, and all clergy, not just Mr Sharpe, are an employee or a worker, and therefore entitled to bring claims to employment tribunals.
So explain what the Church of England's position is on that question.
The Church of England's position, and a position that's previously been upheld by law, is that Church of England clergy are office holders. The common parlance says that they're employed by God. And they say this for a number of reasons. They say that unlike an employee, an incumbent is put into post and is then left to get on with it. And there's very little direction or control that a bishop or a diocese can put over their clergy. It's there for them to decide what they do, how they do it, and what their priorities are. In fact, the case of Trollope's Victorian novels came up during the court, and the judge asked the Geoffrey Tattersall for the bishop and the diocese whether the situation in those novels of a vicar who goes off to live in Italy for 12 years, getting somebody else to do the work, what action the bishop would be able to do today if faced with that situation. And Mr Tattersall replied that he was embarrassed to do so, but that the spirit of Trollope was alive and well, and the bishop would have no power at all to take action in those circumstances.
All right, well, what emerged from the week?
Well, the biggest thing to emerge, I think, was the complete difference of position about what the Church of England is between the diocese and the bishop, and Mr Sharpe and his barrister. The Mr Tattersall for the bishop and diocese painted a picture of this sort of hands-off approach where a bishop has no control at all. And Mr Sharpe's barrister, John Benson, painted a picture that the canonical oath of obedience that all priests have to swear to their bishop, and that the canons of the Church of England meant that an employee pretty much had to do what the bishops told them to do, and if they didn't, then they would be facing disciplinary proceedings. One of the things that came out, because in order to prove an employee there are a number of categories or conditions that have to be met, one of the things that came out was that the stipend that clergy receive, they receive through the grace and favour of the diocese, and there's actually no legal entitlement on clergy to receive a stipend. I think that was the most startling thing that came out during the week. But yeah, quite bizarre.
And all of that could presumably have serious implications for the clergy as a whole and the way the system works.
It has serious implications for the clergy, but not just for the clergy. The judge pointed out to Mr Sharpe's barrister that the position that he was taking in relation to the stipend being not so much a maintenance allowance but a payment for work done, was that all office holders who had previously not been considered to be employees, including judges, including police officers, would be employees if Mr Sharpe wins the argument that he makes. So the implications of the hearing are quite significant, not just for clergy but for many other office holders.
And when do we find out the result?
Well, the judge made clear that he was no clearer at the end of the week to knowing what his decision was than at the beginning. He's advised the parties that he has 3 months that he's allowed to take to make a decision, and he may take those. But then I think we'll still only be at the start of the process, because I think the parties will likely to appeal this to an Employment Appeal Tribunal, and then to the Court of Appeal, and possibly the Supreme Court too.
Gavin Drake.